word Madhyastha is a very commonly used word and adjudicatory process, but it has many challenges. In the Code of Civil Procedure, before 1908 CPC, there was a provision of arbitration in the old Act, old code, but subsequently it was removed. The Arbitration Act came into picture in 1940, and that 1940 Act was repealed in 1996. The 96 Act takes into consideration mediation, conciliation, and arbitration. Arbitration is adjudicatory process where somebody acting as an arbitrator decides the dispute, whereas mediation and conciliation are voluntary settlement with the intervention of a third person. But it is a voluntary settlement, whereas the arbitration is adjudicatory. Our 1996 Act has been amended thrice in 2015, 2019, and 2021, but it has still many challenges. What you will hear about the arbitration is it is ad hoc arbitration generally, where the court appoints an arbitrator under Section 11(6) of the Arbitration and Conciliation Act, where earlier it was titled as Chief Justice of the High Court or Chief Justice of India in the case of international dispute. Now it was changed to the High Court or the Supreme Court. But the fact remains that arbitrators are appointed by the court. If there is no agreement, the arbitrators are appointed by the court. There is unknown clause in section 11(5) and 11(6), where the Chief Justice earlier, now the High Court or the Supreme Court, can designate an institution also to appoint arbitrators. I must have read section 11(6) couple of times, but this part that the institution could also be designated was not known to me, to be honest. I was lucky. Two Honorable Chief Justices of my parent High Court had designated me as delegated me the power of the Chief Justice to appoint arbitrators. I exercised that power for a year each, for almost 2 years. But this fact, nobody argued it, nobody knew it, and actually there was no institution in Punjab and Haryana, I would say so. But I was in 2 other courts, there was also no institution. Delhi has one institution, Delhi International Arbitration Center. Mumbai has one. Hyderabad has one. There are many others. But the court generally appoints the retired judges as arbitrators. There are certain advantages of the retired judges, but certain disadvantages also. In ad hoc arbitration, there is no cap that how many hearings will take place, how much time. Recently in 2019 they fixed time, but still generally it crosses that time limit. But fee is again made part of Schedule 4, that is 30 lakhs, that is upper cap. But recently Supreme Court in a judgment, ONJC versus AFCON, said 30 lakhs is fee which is applicable to claim and counterclaim. So it comes out to be, in a given case, it can come out to be 60 lakhs. But this fee, 4th schedule, is not applicable to the institutional arbitration. Delhi High Court in the Delhi International Arbitration Center is managed by the sitting judges of the Delhi High Court. They have framed new regulations for conduct of arbitration, which are applicable from today, 1st of April is the date of commencement. They have fixed the fee cap of the fee is 60 lakhs. But fee is only one part. The fact is, I'm not very sure that in how many cases Delhi High Court has nominated or designated an institution as an arbitrator. I was appointed as an arbitrator by Delhi High Court, not as institution appointed. Delhi High Court appointed me. There are many other instances where High Court is appointing individuals as arbitrators and not the institutions. In respect of institution, you know, the fee is known beforehand that this will be fee payable, and also the timeline is fixed under the act also, but still you will like to maintain the timeline. But basic advantage between ad hoc arbitration and the institutional arbitration is that where in ad hoc arbitration there is no limit that how many sittings you will conduct, whereas in institutional arbitration, whatever sittings you conduct, there is a cap of the maximum fee which will be paid, and everything is known beforehand. Nobody can have a grievance that I was charged extra. There is a constant problem about high charging of a fee.